gun owners do have privacy rights. They shouldn't be having to look over their shoulder.
This bill is about protecting privacy and for exercising their constitutionally enshrined Second Amendment rights.
Justifiable one. This becoming some sort of a backdoor gun registry.
I urge to oppose this bill, which limits efforts to combat gun violence.
Lawful purchase of a firearm protected by the Second Amendment is not in and of itself suspicious activity.
Right now, every time an American swipes a credit card at a gun store, that purchase can be flagged, sorted, and tracked automatically without a warrant and without the buyer ever knowing. It's a system that took 4 years to build, and this week the House of Representatives voted to kill it. The vote was 221 to 201. The bill is House Resolution 1181, the Protecting Privacy in Purchases Act, and it passed on July 14, 2026. If it survives the Senate, it will permanently ban Visa, MasterCard, and American Express from using a special code to separate gun purchases from everything else Americans buy. Gun rights groups have called that code a backdoor gun registry, one built not by the government but by the financial system itself. But here's what makes this story bigger than one vote. Only 5 Democrats crossed the aisle. A key amendment was killed behind closed doors before the floor ever saw it. 3 states currently have laws requiring the exact tracking this bill would outlaw, and this bill would wipe those laws off the books entirely. To understand what's actually at stake, you need to know how a 4-digit accounting code became one of the most contested Second Amendment fights in Congress. Every time a card is swiped, a code tells the payment network what kind of business the money went to. Restaurants have one, hardware stores have one, pharmacies have one. For decades, gun stores didn't have a code of their own. They were folded into general sporting goods or general merchandise. That changed in a way that quietly turned every firearm purchase in the country into a data point. This story starts years before this week's vote, and understanding the timeline is the only way to understand why a bill about a 4-digit accounting code has become one of the more contested Second Amendment fights in Congress.
California law that will allow banks to potentially track suspicious gun purchases and report them.
Retailers are assigned a 4-digit code based on what they sell.
Detection scenarios say, hey, something's not right here. Take a deeper look. See if there's a problem.
To understand why this matters, rewind to September of 2022. The International Organization for Standardization created a brand new merchant category code specifically for firearms retailers. Almost immediately, Visa, MasterCard, and American Express announced they would implement it. For the first time, every swipe at a gun store or ammunition dealer could be tagged, sorted, and flagged separately from every other kind of purchase, automatically without a warrant, without a court order, and without the purchaser ever knowing. Gun rights advocates called it exactly what it sounded like. A backdoor gun registry built not by any government agency, but by the financial system itself. Nobody voted on it. No court reviewed it. A private standards body created the code, and 3 of the largest payment networks in the world agreed to use it. And that alone was enough to change what every gun and ammunition purchase in America looked like on the back end. The public backlash was immediate. Gun owners, retailers, and advocacy groups argued that once a purchase is tagged and trackable, it doesn't matter whether the current administration says it won't misuse that data. The infrastructure to misuse it now exists permanently, waiting for whoever wants to use it next. That argument found an audience. Roughly 18 states responded by passing their own bans on the practice. Alabama, Georgia, Florida, Idaho, Indiana, Iowa, Kentucky, Louisiana, Mississippi, Montana, New Hampshire, North Dakota, Ohio, Tennessee, Texas, Utah, Wyoming, and West Virginia among them.
Gun owners do have privacy rights. They shouldn't be having to look over their shoulder, justifiable one. This becoming some sort of a backdoor gun registry.
And specifically, this package addresses core areas of national consequence. They affect how Americans live, work, learn, and travel every day. Congress can make tough decisions that are necessary to govern this country and course with President Donald Trump.
Arkansas joined that list this year as well, bringing the total closer to 23 states went the opposite direction entirely. California, Colorado, and New York passed laws requiring the code to be used, arguing it could help law enforcement flag suspicious purchasing patterns, particularly bulk ammunition buys that have preceded mass shootings in the past. That split is exactly why Congress got involved. A patchwork of state rules meant the code's existence still depended entirely on where a retailer happened to be based. A gun store in West Virginia could operate free of it while one in California couldn't, and a customer's privacy protection changed depending on which side of a state line they shopped on. Representative Riley Moore of West Virginia had already fought this fight at the state level, blocking the code as state treasurer before he was elected to Congress. Once in Washington, he introduced House Resolution 1181 to settle the question nationally, arguing that a constitutional right shouldn't come with different privacy protections depending on geography. The bill picked up 132 co-sponsors, including Representative Andy Barr of Kentucky and Representative Richard Hudson of North Carolina. It cleared the House Financial Services Committee by a recorded vote and went to the floor under a closed rule, adopted by the Rules Committee on a party line basis, meaning no amendments were allowed except ones the Rules Committee pre-approved for consideration.
This bill is about protecting privacy and for exercising their constitutionally enshrined Second Amendment rights. Americans have legitimate reasons to be concerned about the weaponization of the financial system.
Rise in the name of the children who've had to look over into the casket and see their parents. I urge to oppose this bill, which limits efforts to combat gun violence.
Only one amendment made it through that gate, and it was a procedural motion to table, not a substantive change to the bill's text. One amendment that did not survive is worth pausing on. A Democratic member offered a change that would have stripped out the language preempting state and local laws on the merchant code entirely, meaning California, Colorado, and New York could have kept their own rules on the books no matter what Congress did nationally. That amendment was defeated in the Rules Committee by a vote of 4-8 before the bill ever reached the House floor, which meant the full chamber never got a direct vote on whether to let blue states keep their own tracking requirements. That single committee vote is arguably where this bill's biggest consequence was actually decided, not preventing a federal registry, but overriding the handful of states that had built one deliberately. When the final vote came on the floor, it broke almost entirely along party lines. Only 5 Democrats crossed over to vote yes. Henry Cuellar of Texas, Marie Gluesenkamp Perez of Washington, Don Davis of North Carolina, Jared Golden of Maine, and Adam Gray of California. All of them representing swing or right-leaning districts where gun rights carry significant weight with voters. Not a single Republican voted no. Opponents of the bill argued the merchant code was a legitimate tool, no different from the codes used to classify any other retail purchase, and that stripping it away removes a resource law enforcement could use to spot patterns tied to gun violence, patterns like unusually large ammunition purchases that in hindsight have shown up before some of the country's worst mass shootings. Some Democratic members invoked recent shootings directly during floor debate, arguing the timing of the vote made the bill look tone-deaf at best.
We really are at a point where continuing to do nothing is not a very good option. The bill would make it easier for mass shooters to stockpile firearms and ammunition undetected.
Lawful purchase of a firearm protected by the Second Amendment is not in and of itself suspicious activity. Respectfully, the right to bear arms is not the cause of violence.
Supporters countered that no other category of lawful, constitutionally protected purchase gets flagged this way, that nobody proposes a special code for pharmacies to track who's buying what medication, or for bookstores to track who's buying which books, and that singling out one constitutional right for financial surveillance sets a precedent that could extend well beyond firearms. They also pointed to internal admissions from gun control advocates, made years earlier, that the code's real purpose was to enable monitoring and eventually denial of certain purchases, evidence in their view that the code was never a neutral accounting tool to begin with, but a policy lever dressed up as a technical standard. Both sides agree on one thing. The underlying data would still exist somewhere on a bank's ledger no matter what this bill does. What the bill actually controls is whether that data gets a special label that makes it trivial to isolate, search, and hand over in bulk versus sitting buried, uncategorized, inside years of ordinary transaction records. So what does the bill actually change if it becomes law? Payment card networks would be barred from requiring a firearms retailer to use a merchant code that identifies it as selling firearms, ammunition, or related components. Banks and other covered financial entities would be barred from assigning that kind of code in the first place. Enforcement would fall to the U.S. Attorney General, who would investigate complaints and could take legal action against violators. There's no private right of action, meaning individual citizens couldn't sue over a violation themselves. And notably, the bill would preempt state and local laws on the subject entirely, including the ones in California, Colorado, and New York that currently require the code. The bill has drawn support from the National Rifle Association, Gun Owners of America, the National Shooting Sports Foundation, the Congressional Sportsmen's Foundation, and Heritage Action. Essentially the full roster of major firearms industry and gun rights groups. The National Shooting Sports Foundation in particular has been pushing this specific fight since the code was first created back in 2022, framing it consistently as a matter of financial privacy, rather than gun policy, a framing designed to make the bill palatable to lawmakers who might not otherwise wade into Second Amendment territory. The White House Office of Management and Budget issued a formal statement of administration policy backing the bill ahead of the vote, signaling it would likely be signed if it reaches the president's desk. That's a significant marker. A formal administration policy statement is typically reserved for bills the White House considers a real priority, not routine legislation. Now it heads to the Senate, where the path is far less certain. A companion bill, Senate Bill 1715, was introduced by Senator Bill Hagerty of Tennessee back in May of 2025, and already has 16 co-sponsors, including Senators Jim Justice, Lindsey Graham, Mike Crapo, Cynthia Lummis, and John Barrasso. Unlike the House bill, which had to fight through committee and a contested floor vote, the Senate version has been sitting in the Committee on Banking, Housing, and Urban Affairs, picking up co-sponsors quietly for over a year without the same public fight. But sitting with co-sponsors isn't the same as passing. The Senate isn't the House. Any bill needs 60 votes to overcome a filibuster. And with the chamber closely divided, 60 votes for a bill that passed the House almost entirely on party lines is not a given. 16 co-sponsors plus whatever Republican votes come along for free still leaves a real gap to close before this reaches the president's desk. Getting 5 House Democrats across the aisle in a closed rule floor vote is one thing. Getting a comparable number of Senate Democrats to help clear a filibuster on a bill this closely associated with gun rights messaging is a considerably higher bar. That leaves the Protecting Privacy and Purchases Act in a familiar spot for major gun-related legislation passed by one chamber, backed by the administration, and now facing the much higher bar of the Senate floor. Whether it clears that bar or joins the long list of gun bills that pass the House only to stall out is the question that will decide whether this fight over financial privacy and the Second Amendment ends here or keeps going state by state the way it has for the last 4 years.